the State of Ohio versus Diamante Harris, case number 24-CR-473. Defendant is present and represented by defense counsel. Defendant is currently on community control sanctions from a case where he pled guilty to having weapons under disability, a felony of the 3rd degree. He was sentenced on October 7th of 2024. A motion to terminate community control sanctions was filed on November 18th of 2024. That is the motion before the court today.
Thank you. Mr. Ramsey, what is the defendant's intention at this time regarding this final hearing? Does he want to have the hearing, or does he want to waive the hearing and admit to the violations?
Your Honor, we will waive the hearing and admit to the violations.
Thank you. Mr. Harris, you have been charged with violating the conditions of your community control sanctions. Specifically, there are 3 alleged violations. First is a Rule 6 violation. Rule 6 prohibits you from purchasing, owning, possessing, or having under your control any firearm, dangerous ordnance, or deadly weapon. And it's alleged that upon conducting a home visit on November 14th, 2024, a Taurus PT 738 handgun was found underneath the mattress in the bedroom which you were sleeping in. The next violation is another Rule 6 violation for the same rule dealing with firearms, alleging that during the home visit on that same day, a Glock firearm was found, a Pro TA Tactical Prop 15 short barrel rifle was found. Am I missing one? Oh yeah, two Glocks were found, correct? 2 Glock firearms were found, and then the short barrel rifle was found. And those were found in a floor kitchen cabinet that you described to the officer where those firearms would be, to the probation officer where those firearms would be. Lastly, is alleged violation of Rule 8, which prohibits you from using, possessing, or having under control any controlled substance not prescribed to you by a licensed physician. It's alleged that 313 grams of marijuana, which were in 13 individual baggies, I believe, was found in that cabinet where the 3 firearms were. Now, you have the right to have a final hearing regarding these allegations. That's a hearing where the state would be required to prove the merits of what they're alleging. You could have this hearing, but you can also waive the hearing and admit to the violations. Your attorney has indicated, as you just heard, that he believes you want to waive the hearing and admit to the violations. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to a total of 5 years. It was originally put at 2 years just a few months ago. I could impose more restrictive sanctions, including order that you serve time in our Lake County jail, or I could terminate your probation and send you to prison. If I did that, it could be 9, 12, 18, 24, 30, or 36 months in prison. Do you understand the potential penalties you face if found to have violated your community control sanctions?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and admit to the violations?
Admit to the violation.
Very well, then, as to the allegation, the first allegation that you violated Rule 6 by possessing the firearm that was found under the mattress, what is your plea to that?
Guilty. Guilty, Your Honor.
As to the allegation of Rule 6 involving the 3 firearms in the kitchen cabinet, what is your plea to that?
Guilty, Your Honor.
And as to the marijuana charge, the Rule 8 violation involving the marijuana, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Ramsey, any reason not to go forward with sentencing?
There's no reason not to go forward, no.
Anything you want to say on behalf of your client?
Yeah, thank you, Your Honor. Mr. Harris, as the court indicated, he was in a bedroom and under the mattress. Now, several people slept in this bedroom, but under one of the mattresses, there was a firearm. He's admitted to that violation. And on the way to here to the Lake County Jail, he actually told probation officer where other guns were and where the marijuana was and how to get into it in the kitchen cabinet. And I was just talking to him. You know, he seems very, very nervous and very scared. This case is, I think, is his only conviction that's on his record at this time because of expungement in juvenile court. And I was talking to him, and I was telling him that when you get placed on probation, and you can't be around firearms, anyone you live with, family, and maybe they have firearms, you have to tell those people, get all the guns out the house, or I'm going to be violated. And I think, whose guns they actually were is a different type of question, because he definitely clearly knew that the guns were there. He told law enforcement how to get to the guns. And so I've told clients in the past, Judge, that when you get placed on probation, your whole family kind of is on probation because you can't be around any firearms, you can't have any in the house or anything like that. He is very sorry. He's very scared right now. I think he's written to this honorable court. He's supported in the courtroom by family members who also will work hard to make sure he does not violate any conditions that this honorable court would give him should the court continue him on community control sanctions. He's very nervous, very scared, has a wife, he has aspirations. He said he'd just been hired at Potbelly, some restaurant I think in Euclid. But we would ask this honorable court to give him one more opportunity, one more chance to show the court that he can abide by those conditions and not be around any firearms. Lastly, he just said to me, he said, I don't want this life anymore, being around guns and things of that nature. And we'd ask the court to give him one opportunity. Thank you.
Thank you. Mr. Harris, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yeah.
I did receive the letters that you've written to me, and I've read those, but you have certainly have a right to say anything here.
Yes, I wrote a letter. If I can read it, if I may.
You can do whatever, say whatever you'd like to say.
I want to start off by apologizing to the courts, the bailiff, my PO, Ms. Jamie, Mr. Craigberry, my family, my girl, most importantly to you, Your Honor. I truly come to ask for your forgiveness and hope I can show you guys that I've changed for the better. I no longer want to live this lifestyle anymore. Being incarcerated taught me a very hard lesson that I may not want it, but need it. You may ask what the lesson that I've learned. Well, for starters, is to not get on you guys' bad side ever again, and to always think before I do anything, and to make positive choices moving forward. And remember that every action has a reaction, whether it's good or it's bad. Another lesson is time. Me being away from my family, it was rough. Seeing my mom struggling and trying to take care of a full house, I always tried to help out. She is my best friend, and growing up, she raised me right. I hate putting her through this because of my other brother being incarcerated. And it took a toll on her already. So much has happened within the last few months, and I carry this burden like everything is my fault. My grandmother has been sick, in and out the hospital for a while. She is my heart, but I feel like I'm slowly losing her. 3 days ago, my girl was brutally beaten by her first child's father. She was 4 months pregnant with my child. She had a miscarriage. My heart shattered. I've been depressed, disappointed, hurting. Cannot stop crying, blaming myself because these things wouldn't happen if I was there. I was excited to become a father, and he took that away from me. My joy, my hope, and happiness is gone. She is falling apart, and I would love to beat her for her. I made a stupid decision on her. I'm not that type of person. Under these skin and tattoos is an intelligent, smart, kind-hearted, caring kid. I'm not built for this. I'm begging for one chance. It's all I need to show my maturity and my improvement I've been working on. I've grown so much mentally and physically. I know I can make you proud again. I'll never do nothing like this again. I read a lot of books in here, and there was this one quote in this book that stood out to me. It said, "Speak with your mouth and believe in your heart. Your old self has been crucified with Christ. It is no longer who I live anymore." and I replaced it with a new me who has a purpose and wants to do and be better. I promise it's given a 10. If given a chance, I'll attend every meeting and visit, and to keep my sobriety going. I look forward to finding a mentor to help me achieve significance and generational wealth. I'll also like to do AA meetings or any type of therapy. It will also help me out a lot to keep me on track. I appreciate you for your time, Your Honor. I swear and promise to never let you down again. You have my word.
Anything else you want to say?
No, Your Honor.
Mr. Ramsey, anything else?
Nothing else, Your Honor.
For the State of Ohio, Mr. Kresge?
State defers to the court, Your Honor. Thank you.
This court has reviewed the original pre-sentence report investigation. I've considered the facts and circumstances of the underlying offense, the nature of that, but also the nature of the probation violations here. Considered everything that's been said here. And considering all the foregoing, I'm going to incorporate all the findings I made at the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with the imposed sanctions of this court, previously imposed sanctions of this court, which is a factor indicating recidivism is more likely. Now, here's the problem, Mr. Harris. There are certain violations which are much worse than other types of violations. And what you did here is the more serious of the serious violations. And you present fine, you read, you can write letters, you can act like you're upset, and you truly are upset. But your conduct doesn't show that. You got a large break when you were here last time, because I took into consideration all the circumstances surrounding what had happened. And I understood what you said had happened, and your explanation as to not realizing that you had that adjudication still there. And what did I do? I gave you nothing. I put you on probation with no jail time.
Yeah.
You had 4 days of jail, and I gave you 4 days of jail and let you walk out here. And what did you do? Within days, you're posting pictures on Instagram of you holding firearms and all this cash. Within days. Now, maybe that picture was taken a while ago. I don't know. But you posted it 2 days later. What was the point of that? 2 days after you get probation, I let you walk out that door on a gun charge. You're posting pictures of yourself holding guns and cash.
It was stupid of me.
It was stupid of you. But then what did you do? 2 to 3 weeks later, on your Instagram live page, you're selling a firearm. Now, maybe it wasn't you, maybe it was someone else, but it's on your Instagram page. You let someone, if it wasn't you, and I won't say it was you because we can't see if it was you, but you let someone on your Instagram page sell firearms. So this all happens within a month of me letting you walk out that door on a gun charge, taking into consideration the tears and how upset you are, what you had to say, and this is how you act. This violation is one of the worst violations you could commit when you're on probation for a gun charge, and then you get found to have all these guns. You've shown that you're not going to listen to what. It doesn't matter what we say. You're going to do whatever you want to do.
No, Your Honor.
It's clear to the court that you're not amenable to available community control sanctions. To engage in the conduct that you engaged in after being put on probation for a gun charge, and to post pictures of yourself with guns, and to sell a gun, or at least not using your Instagram page to sell the gun. It blows me away.
It was retarded of me, and I promise to you I would never do nothing like
I've
this.
heard these
ever
promises
again.
last time and let you walk out the door because of the promises that I heard. So you're not amenable to available community control sanctions. Prison's consistent with the purposes and principles of sentencing. Therefore, it will be a sentence to this court that community control sanctions be terminated. The defendant be ordered to serve 12 months in prison. He has credit for 107 days he's already served. I need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another, in this case, 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Mr. Kresge, is there anything else for the record?
No, Your Honor.
Mr. Ramsey.
No, would the court consider waiving fines and costs? I don't know if that's already happened at these.
So fines and costs will be a part of
Your Honor. We're here this afternoon in the state of Ohio versus Michael Ketterman, case number 24 CR 1454. The defendant is present, open court with his attorney, Ms. Tomasic. We are here today for an information hearing. It is the state's understanding that the defendant will waive his right to be indicted by the grand jury and plead to count 1, failure to comply with order or signal of a police officer, a felony of the 3rd degree, as well as count 2, possession of cocaine, a felony of the 5th degree with that attached forfeiture specification. There is an agreement as to sentencing between the parties of a term in prison of 36 months, as well as an agreement of $1,000 in restitution, Your Honor.
Thank you. Ms. Thomas, does that all sound accurate?
Yes, Your Honor, that is accurate.
Mr. Ketterman, were you able to hear what the prosecutor had to say regarding what she believes your plans are here at this time?
Yes, sir.
Excuse me. She indicated to the court she believes that your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment what that means, and then plead guilty to the 2 charges in this information, which I will also review with you to make sure you understand those. We would then proceed straight to sentencing. You're waiving a pre-sentence investigation, and there's a joint recommendation that a 36-month prison term be imposed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor on what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. Now, if at any point during this questioning, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, right?
Yes, sir.
All right, let's get started then. How old are you, sir?
56.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No, just the antidepressant medication I take.
What is that, if you know?
Yeah, it's Zoloft and hydroxyzine.
Do either of those medications affect your ability to understand or appreciate where you are or what's going on around you?
No, sir.
So you're not under the influence of those medications right now, and that's negatively impacting you in any way, are you?
No, sir.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're going to be pleading guilty to?
Yes, sir.
In count 1 here, which you're admitting to and pleading guilty, it's alleged on or about December 14th, 2024 in Lake County, Ohio, that you did operate a motor vehicle so as willfully to elude or flee a police officer after you received a visible or audible signal from the police officer to bring your car to a stop. It's further alleged your operation in the motor vehicle causes substantial risk of serious physical harm to persons or property, which makes the offense failure to comply with an order or signal of a police officer a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, sir.
Any questions about it?
No, sir.
Now, count 2, it's alleged on or about December 14th, 2024 in Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount was less than 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, sir.
Any questions about that?
No, sir.
Now, this charge also carries with it a forfeiture specification alleging during the commission of the offense you possessed or had an interest in property considered to be contraband or an instrumentality, that being a glass smoking pipe. The purpose of this is that you'll forfeit any right you have to that pipe. Do you understand that?
Yes, sir.
Any questions about it?
No, sir.
Well, then, before I can accept your guilty plea to these 2 charges, I need to make sure you understand all the rights you're giving up. And first of all, you have the right to have this case presented to a grand jury. So that document that I just read to you is called an information, and an information is a criminal charge brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County who get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Now, everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor and the information. And your attorney has indicated she believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession at this time a document, one-page document called a waiver of indictment, which sets forth and explains what I've just explained to you about the grand jury process, and that you want to give up that right. Before I can go any further, I need to make sure you understand that document, that you sign it here in court. My understanding is before I came out here, you had a chance to review that document with your lawyer. Is that correct?
Yes, sir.
Ms. Tomasic, is that accurate? Did you read this over with Mr. Ketterman and review it with him?
Yes, Your Honor.
Did he indicate an understanding of it to you at the time?
Yes, he understood the document, Your Honor.
Is that correct, Mr. Ketterman?
Yes, sir.
You can be seated. I don't interpret that as any disrespect. You understand what the document says?
Yes,
Any
yes, sir.
questions for me about it?
No, sir.
Now it appears you signed the document. Did you sign it?
Yes, sir.
Ms. Tomasic, you witnessed that?
Yes, Your Honor.
And Ms. Cantor?
I did, Your Honor.
Very well, then at this time, I will make this document part of the record. At this point, Mr. Ketterman, I'm going to advise you of all the other rights you have that you're given up by pleading guilty. And you first of all have a right to a trial. A trial could be to me as a judge, or I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. That means all 12 jurors would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
You understand by pleading guilty or giving up your right to have a trial in this case?
Yes, sir.
Now, if we did have a trial in this case, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility, the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when we speak of that burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the offenses beyond any reasonable doubt before you could ever be found guilty at a trial of these charges. Do you understand that?
Yes, sir.
Do you understand that by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least try to do that if we had a hearing in this case, the prosecutor would bring witnesses to come into court to testify on behalf of the state by answering questions from the prosecutor. And after those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. She could ask him, anything she wanted to, within certain rules. You understand that?
Yes, sir.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that. You're not obligated to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. So what that actually means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she's not allowed to call you as a witness, force you to get up on the stand and testify and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if you went to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court and then you will subsequently be sentenced by the court. You understand that?
Yes, sir.
Now, as far as possible sentencing goes, you're pleading guilty in count 1 to a felony of the 3rd degree. This particular felony of the 3rd degree is punishable by a possible term in prison of a minimum of 12 months, a maximum of 60 months, or increments in between of either 18, 24, 30, 36, 42, 48, 54. So if I determine a prison sentence is warranted, I'd select one of those numbers that I just mentioned, between 12 and 60, with every 6-month increment as a possible choice, and that'd be the number of months in prison you'd have to serve. You understand that?
Yes, sir.
Now, for count 2, it's a felony of the 5th degree. It's punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, in regards to these two offenses, count 1, the legislature requires that if I impose a prison sentence on that count, any other prison sentence that gets imposed for any of the other counts must, by law, be served consecutive to the prison sentence imposed on the fleeing and eluding charge. So if whatever prison sentence I impose on count 2 would have to be served consecutive to whatever prison sentence is imposed in count 1. I do not have the discretion to run the sentences concurrent or together. Do you understand that?
Yes, sir.
So in this case, if I impose the maximum sentence on each count and I ran them consecutive, you're looking at a maximum possible prison sentence of 72 months or 6 years in prison. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole to any other courts or agencies?
No. No, sir.
Not on PRC?
No, sir.
Any other charges pending against you? I know there's that other case here. That part of the deal is that gets dismissed. But aside from that other case, anything else?
No, sir.
If a prison sentence is imposed in this case, upon your release from prison, it could be placed on post-release control. If I find that the offense involved here in count 1, the fleeing and eluding charge, is an offense of violence, which means that you acted willfully or purposely, and that it caused a substantial risk of serious physical harm to persons, I would have to find that that conduct constitutes an offense of violence. And if I make that finding, and I haven't heard the facts yet, but if I make that finding, then post-release control is mandatory in this case for at least 1 year, and it could be up to 3 years. If I don't make that finding, and therefore don't find it to be an offense of violence, then post-release control is discretionary. It's up to the parole authority to decide that. In that circumstance, it would be for up to 2 years. You understand that, the difference there?
Yes, sir.
Post-release control, it's a period of supervision you would be on after you serve the prison sentence. And again, depending on whether this is an offense of violence or not, it's either going to be mandatory for 1 to 3 years or discretionary for up to 2 years. And that all depends on what the determination I make as to whether this is an offense of violence or not. Do you understand that?
Yes, sir.
Any questions about that?
No, sir.
Now, if you are on post-release control and you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, or whatever the prison term is imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that can be imposed, some that must be imposed. I could order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir.
I could also impose a fine in this case on the fleeing and eluding charge. There's a possible fine of up to, would it be $10,000? On the drug charge, it could be a possible fine of up to $2,500, so a maximum fine here of $12,500. You can also order that you pay restitution to any for any economic loss any victim may have suffered as a result of the conduct. Do you understand all that?
Yes, sir.
There's also a mandatory driver's license suspension in this case, and in this particular case, since I've been advised that you have a prior conviction for failure to comply with an order or signal of a police officer, I will be required to permanently revoke your driver's license for the rest of your life. You understand that?
Yes, sir.
Also, in regards to that, I mentioned it earlier, that forfeiture specification, any right, title, or interest you have, I think it was a glass pipe that was a paraphernalia, that'll be forfeited to the state of Ohio. Do you understand that?
Yes, sir.
Now, a few moments ago when I explained the possible prison sentence, I used the word possible. Prison is not mandatory in this case. You are technically eligible for probation, or what we refer to as community control sanctions. You understand that?
Yes, sir.
You understand just because you're eligible doesn't mean it would automatically be granted. I mean that I would consider it if that's what was being requested. I'd look at all the information and make the decision that I thought was the right thing to do. You understand that?
Yes, sir.
Now, if you were, strike that. To be considered for community control sanctions, a pre-sentence report investigation has to be completed, which is a report the probation department puts together for my benefit to give me information about you and your background. That must be done in order to be eligible for community control sanctions. Now, I've been advised that you're waiving a pre-sentence report and requesting to proceed straight to sentencing. Is that correct?
Yes, sir.
So do you understand that while this offense is a probationable offense, I will not be able to consider that as an option at the time of sentencing?
Yes, sir.
Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want. Anything you'd like me to know or consider. Your lawyer can speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand all that?
Yes, sir.
You understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I don't think it's the right thing to do. You understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer and have her go over the reports with you and discuss whatever issues there may be?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has she or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, Mr. Ketterman, any questions for me at this time regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're actually pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her and what she says, because I will have some follow-up questions for you, all right? Ms. Contour?
Thank you, Judge. this matter would have proceeded to trial, evidence would have shown that on December 14th of 2024, in Lake County, Ohio, officers in Willowick did attempt to make a traffic stop on the defendant's vehicle on Route 2. After activating their lights and sirens, the defendant did not comply, did not stop his vehicle for a period of about 7 minutes, spanning 5 miles, and during that time, the operation of the motor vehicle caused substantial risk of serious physical harm to persons or property. When he was finally pulled over, when the vehicle was searched, a smoking pipe was found on the front seat of his vehicle that was sent to the Lake County Crime Lab and confirmed to contain cocaine.
And I need you to put some more specific facts in regards to the...
Your Honor, I didn't know if you would like me to now or at the time of sentencing when you make the finding about...
I'll do it now.
Okay. So this started at around 4:05 p.m., Your Honor, on a Saturday, so there was very heavy traffic on Route 2 throughout this time. So his license plate had been placed into flock for an earlier offense. So before Willowick even attempted to make this traffic stop, the Lake County Sheriff's Office had attempted to make a traffic stop based on that flock hit. They did not pursue, and so when he came into Willowick, officers attempted to pull him over. They went through Route 2 onto 90, and at the bridge, at the 305 bridge, officers attempted to throw stop sticks at that time. That was unsuccessful. That was after 4 minutes of the chase. They then continued on to the State Route 2 and I-90 split, where officers of Wickliffe and Willoughby once again attempted to throw stop sticks. That was evaded by both the officers and the defendant going up onto the left side of the highway in order to evade that. About 6 minutes into this pursuit, one of the Willowick officers attempted a first pit maneuver by attempting to hit the end of the defendant's vehicle in order to cause him to spin out. That was unsuccessful. During those first 6 minutes, the defendant was only going about 50 miles per hour. However, after that first pit maneuver was attempted, he considerably sped up to 90 miles per hour and then was going around the I-90 bend, and traffic was almost entirely stopped, causing the defendant to have to stop. A second pit maneuver was then successful, and then officers were able to surround the vehicle and pull the defendant out. During that time, one of the Wickliffe cruisers was struck, and so all in all...
By who? By what?
I'm sorry?
By the defendant's car?
Yes. And then during
When did that happen?
during surrounding his vehicle and the pit maneuver in order to attempt to stop his vehicle, Your Honor.
Okay.
So it was 5 different departments, being Willoughby Hills, Wickliffe, Willowick, Willoughby. There was a sheriff's office at one point, and 11 different officers who were all in their cruisers were attempting to throw stop sticks during this time in order to stop the vehicle, Your Honor. So we would ask the court to
How
find...
long overall was the
7 minutes, Your Honor, spanning approximately 5 miles of Route 2 and I-90.
Thank you. Mr. Ketterman, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial in this case?
Yes, sir.
What, if anything, did to say about those facts as she presented them? And I'm only worried about the second, or the first one was just giving some background information. You're not admitting to anything for that. But in regards to what she had to say regarding the facts, are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1, charging with failure to comply with an order or signal of a police officer, felony of the 3rd degree, what is your plea to that count?
Guilty.
Regarding count 2, charging with possession of cocaine, a felony of the 5th degree, what is your plea to that count?
Guilty.
All right, at this point, I have in my possession another document. This is a 4-page document which sets forth everything I've just reviewed with you. The rights you're giving up, penalties you face, what you're pleading to. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you've signed it here in open court. Now, again, my understanding is before I came out here, you had a chance again to review this with your attorney. Is that correct?
Yes, sir.
Ms. Tomasic, is that accurate? Did you read this over with your client and review it with him?
Yes, Your Honor.
Did he indicate an understanding of it to you?
Yes.
Is that correct, Mr. Ketterman?
Yes, sir.
Understand what the document says?
Yes, yes, sir.
And it appears that you signed the document. Did you sign it?
Yes, sir.
Ms. Tomasic, you witnessed that?
Yes, Your Honor.
Ms. Cantor?
I did, Your Honor, and I know it's a very small thing, but you did not have the defendant plead guilty to the forfeiture specification.
Oh, so I meant to do that. Let me back up there 1 second. The forfeiture specification to count 2, what is your plea to that? In regards to having the glass pipe?
Oh, guilty.
For the forfeiture purposes is all it is. Yeah.
Guilty.
Okay. All right, then at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, failure to comply with an order or signal of a police officer, a felony of the 3rd degree in violation of 2921.331B, as well as count 2, possession of cocaine, a felony of the 5th degree in violation of 292511, with the forfeiture specification. Ms. Tomasic was alluded to earlier that the defendant's waiving a pre-sentence report. Is that correct?
That's correct, Your Honor.
Is that accurate, that what you want to do here, Mr. Ketterman?
Yes, sir.
So you understand I can't consider community control sanctions as an option. You understand that?
Yes, sir.
Then, Ms. Tomasic, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing today.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We just want to ask the court to adopt the joint recommendation of the parties for the 36 months in prison. Since day one of this case, speaking with Mr. Ketterman, he has taken full responsibility for his actions, and he deeply regrets his actions. He indicated to me, and he knows that he does have an issue with drugs and alcohol. He indicated it's no excuse for his actions, but it definitely played a huge part in what had happened. Prior to us reaching the agreement on the 36 months, he was reaching out to our social worker and reaching out to Alpha House to put himself into a drug treatment program and an alcohol treatment program to help get him a good support system. He indicated to me he's been in prison, in and out of prison most of his adult life, and he wants to break that cycle, and he knows he's the only one that has the power to break that. He indicated after his prison sentence, he is still planning to go to Alpha House if it is available, or go to some sort of other treatment center. He knows he needs to get the drug issue and alcohol issue under control, and he knows that he cannot do it on his own. He knows he needs that help, and he's willing to do whatever it takes after his prison sentence to make sure that he never goes back to prison again, or never comes to a courtroom or picks up new charges again. Thank you.
Thank you. Mr. Ketterman, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah, can I, is it all right if I tell you kind of what was on the stand? Is it
You
okay
can
if
say
I-
whatever you want to say.
All right, 64 days before I was released from prison the last time, my mom committed suicide. It was a horrible, we were really close, and there was just a tremendous amount of guilt and sadness that I was feeling when so I left and I moved in with my girlfriend, but I couldn't talk to her. I didn't want to be around anybody. I fell in this real dark depression. We ended up breaking up, and I lived in my car for a year. Didn't talk to anybody. In the last 2 years, I tried to deal with the depression with alcohol and drugs, which was a mistake, but it was my decision. I was in and out of Laurelwood Hospital more times than I can count. Suicide attempts, and a couple of times I went there on my own for detox. I thought if I could just, get the stuff out of my system, I'd be all right, I could get it together. But I'd fall on my face every time. The last time I seen my mom alive was in this courtroom. She was sitting behind me asking Judge Lucci not to send me to jail. It's my mom, she, you know. Anyways, since I've been in jail, I lost everything. Everything I own, everybody I loved and cared about, it's all gone. I found myself in this place. This AA book I've been reading. They call it Rock Bottom, and sitting there in that jail cell, I realize I see things clearly now. Clearly, I'm selfish, self-centered, and dishonest, and there's no excuse for it. The other thing that I realize is that I am the cause of all of my problems. You know, there's never, alcohol and drugs are just a symptom of some thinking problem that I got. You know, it's not, I'm the cause. You know, it's not drugs, it's not depression, it's my thinking. You know, and I come to believe that my situation is hopeless, is absolutely hopeless. And the only thing I can hope for really is if God would help me, you know. And that's where I'm at with my whole life, you know, like I've been asking God for direction. I didn't get no answer, nothing. And in the big book it says, you know, that's my only hope, and I believe that. And so I'm gonna go to this place when I get out of prison, this one-year program. In the meantime, you know, I'll just keep asking God for help and try to live by these principles that they talk about in this AA book, you know. Try to be not selfish, not a liar, you know, try to be helpful. That's the person I want to be, not this scumbag I've been my whole life, you know. I don't want that anymore. I want to get out and try to make up for some of the horrible things I've done, and my children, they're adults now. I need to make up to them. The $1,000 I owe for the police car, I'll pay that, but I need some time, Judge, because I don't have any money. But I'll pay it when I get out. I'm truly sorry for what I did, and not just because I'm in jail and I lost everything, but because I figure it's one thing if I just want to sit in some corner and drink myself to death, but it's totally different when I pull other people. You know, other people were affected. It could have been, you know, bad, and that's wrong. You know, that's not what I don't know what I was thinking, but I was thinking I'm going to lose my job, I'm going to be homeless again. I was thinking I'm going to ruin Christmas for my kids, but it was all these, I don't know, it was all wrong, you know. And so I guess just to make it short, I'm really sorry for what I did, and I don't have no excuse for it. There's absolutely no excuse for it at all. That's all I got to say.
Thank you, sir. Ms. Thomas, anything else?
Nothing further, Your Honor.
Ms. Contra for the state of Ohio?
Thank you, Your Honor. I believe I've already placed on the record any facts that the court would need in order to understand why this agreement was made with regards to his history. He does have an attempted failure to comply in 2005 and a F3 failure to comply in 2006. He was sentenced consecutively on those, and he got out in 2011. In 2012, he had a robbery in which he spent 3 years in prison, and then went to prison again in 2021 from this court and 2022. So we do feel that the 36-month agreed recommendation is appropriate and would ask the court to adopt it.
Thank you. This court has considered the facts and circumstances of the offense involved as it was related to the court during the plea. I've considered what's been said here in court by Mr. Ketterman, his lawyer, the prosecutor, the joint recommendation. I've considered all this in light of the purposes and principles of felony sentencing, which are set forth in 29-29-11. For the factors in the 29-29-12, factors indicating the conduct is more or less serious. For the seriousness factors, the court is not only required to consider the factors under 29-29-12, but also the factors in 29-21-331, dealing with the nature of the driving and the, in this case, the court finds there were multiple moving violations. The defendant was driving in the middle of a Saturday afternoon with heavy traffic, reached speeds of 90 miles an hour. Another cruiser was struck during this chase. They were lasted 5 miles, period of 7 minutes. Multiple departments, multiple officers involved. Those are all factors that make it more serious. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions, has previously served a prison term before, multiple prison terms. He has failed to comply with previously imposed sanctions ordered by courts. Nothing indicates recidivism is less likely. The court finds that prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. Therefore, be the sentence of this court that on count 1, failure to comply charge, defendant serve a term in prison of 30 months. On count 2, defendant serve a term in prison of 6 months. Those two sentences by statute must be served consecutive to each other for an overall prison term of 36 months in prison. I've calculated 74 days of credit.
Your Honor, since this has occurred, he did plead to a misdemeanor theft case in Willoughby Muni. Ms. Tomasic might be able to speak better to that, but the sentence he was given did use the credit since he had been in. That makes sense.
From that day?
From December 14th. I believe that there was a probable cause warrant out for his arrest, and so when he was arrested, he was sent to Willoughby Muni and recently pled to that theft case. Judge Cronaccio sentenced him on that and used the credit since December 14th.
Oh, then there's no credit on this case then. I'm further going to order going to pay $1,000. Which department would that be?
Wycliffe, Your Honor.
Wycliffe Police Department. $1,000 for restitution, for the pay court costs. Court further finds, based on the facts in this case, that this offense is an offense of violence, and accordingly, part of this sentence will be an order that upon your release from prison, you be placed on post-release control for a minimum of 1 year up to a maximum of 3 years. While in post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court. I'm going to order the forfeiture of the contraband in the forfeiture specification in count 2. And the court finding the defendant does have a prior conviction for failure to comply with an order of signal of a police officer. The court is required to suspend the defendant's driver's license, and I am required to do that as a Class 1 suspension, which is for a definite period for the life of the defendant. So the defendant's license will be suspended for the life of the defendant. I think that covers everything, right? Forgetting anything?
I don't believe so, Your Honor.
Tomasic?
No, Your Honor. Thank you.
All right, thank you all.
All rise.
Your Honor, we're here in the state of Ohio versus Amanda Johnson, case number 24 CR 1367. The defendant is present with counsel Bill Watson. A 3-count indictment was filed in this case on December 20th, 2024. Count 1 is theft from a person in a protected class, a felony of the 4th degree, and violation of Revised Code 2913.02A1. Count 2 is identity fraud against a person in a protected class, a felony of the 3rd degree. And count 3 is identity fraud against a person in a protected class, a felony of the 4th degree. The state has offered for the defendant to plead guilty to count 1, and at the time of sentencing, we would ask for the remaining 2 counts to be dismissed. And there is no agreement as to sentencing.
Thank you. Mr. Watson, is all that accurate?
Thank you, Your Honor. Please, the court. Yes, that is accurate. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had a chance to discuss this matter with my client. She is prepared this afternoon to enter a change of plea. She understands that by doing so, she will be waiving certain constitutional rights, and no threats or promises have been made in order for her to do so, Your Honor.
Thank you. Ms. Johnson, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here?
Yes, sir.
It was indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to count 1. The remaining 2 counts would get dismissed. We would defer sentencing to get a pre-sentence investigation completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding, the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
All right.
Give me 1 second. What I'm looking for here is that I think there's a separate mandatory fine that's required for people that are convicted of this offense of up to $50,000. It could be $1, it could be up to $50,000, but that's in addition to the $5,000 fine that would normally for felony in the 4th degree. So there's a potential fine of $55,000. The mandatory fine, I guess at least $1, but it's under 291302 3, it reads that the victim of the offense is an elderly person. In addition to any other penalty imposed for the offense, the offender shall be required to pay full restitution to the victim and to pay a fine of up to $50,000. So I'm going to change the form for that.
I apologize, Your Honor.
All right, well, let's get started then. How old are you?
34.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before coming into court here this afternoon, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
I'm prescribed depression medicine. That's it.
Have you taken it in the last 48 hours?
Yeah.
You're saying, like, you're going like this, but saying, yeah.
Yeah, I mean, it's not a drug, but...
Well, I didn't ask you about a drug. I said,
Oh.
have you taken any prescribed medications
Oh,
in the
yes.
last 48 hours?
Sorry. Yes. I don't even know
What is
it's
it?
called.
Do you know what it's called, or is it just for depression?
I don't even know what it's called.
Okay,
The
but it's for
jail
depression?
did it, yes.
Okay. So I'm just changing the form here that says you haven't taken any drugs or alcohol in a 48-hour period except before this hearing, except for depression medication. Is that accurate?
Yes.
Okay. Does that medication in any way affect your ability to understand or appreciate where you are, what's going on around you?
No.
That's why I'm asking the question. I want to make sure you're a clear mind right now and you're not being negatively impacted by any drugs, whether legal, illegal, prescribed medication, anything. So does this medication in any way negatively impact you at all?
No.
All right. Did you receive a copy of the indictment in this case? I know you got it sometime. It appears back in December, the document that sets forth the charges.
Yes.
You had a chance to look that over?
Yes.
In that indictment, you're charged with 3 counts. And count 1, what's alleged and what you're pleading guilty to, is on or about December 22nd, 2023 in Painesville Township, Lake County, Ohio, that you did with purpose to deprive Robin Lee Spooner, the owner of property, that being U.S. currency, that you knowingly obtained or exerted control over the property, that U.S. currency, without her consent or anyone else authorized to give consent. It's further alleged that at the time of this offense, Robin Lee Spooner was an elderly person, being 68 years of age at the time, and that the value of this property was more than $1,000. So that conduct constitutes the offense of theft from a person in a protected class. It's a felony of the 4th degree. Do you understand what you're charged with pleading guilty to in regards to this count?
Yes.
Any questions for me about it?
No.
Now, there are 2 other counts in this indictment that are being dismissed. Is that your understanding?
Yes.
Do you have any questions about any of those other 2 charges?
No, sir.
Well, then before I can accept your guilty plea, I need to make sure you understand the rights you're giving up by pleading guilty. You first of all have a right to have a trial in this case. And that trial could be to me as a judge, where I listen to all the evidence. Then I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all the evidence, and those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, guilty or not guilty, as to each charge in the indictment. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means, it's her job, where she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of these charges, and that presumption of innocence will stick with you and stay with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes.
Now, when I talk about this burden of proof, since we're dealing with a criminal case here, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge beyond any reasonable doubt, before you can ever be found guilty at a trial of this charge. You understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that if we had a trial in this case, the prosecutor would be bringing witnesses to come into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses
Yes.
that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Mm-hmm. Yes. Sorry.
That's right. You further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right.
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she's now to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding I will make if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this date. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
You still want to plead guilty?
Absolutely. Yes.
You understand a guilty plea is a complete admission of guilt, which means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Sorry?
Yes.
Now, are you currently on probation or parole, post-release control, any type of supervision in any other courts or agencies?
Not in the state. In Maryland, I'm
Okay.
not ordered to probation.
If I may, Your
Please.
Honor, right before she was picked up for this case, my client did a year in prison in Maryland, and then she was transferred from Maryland directly here. So she might be on some kind of supervision. She had finished her sentence there. I don't specifically know if they have her on any supervision or not, though.
Were you on supervision or could have been on supervision when this was done?
No.
Okay. That's what I care about, really.
Okay.
When this offense occurred, were you on any type of probation or supervision?
No.
Anywhere?
No.
Okay. Do you have any other charges pending against you right now anywhere?
Yes.
Where's that?
Summit County and
Cuyahoga.
Cuyahoga, and also Tennessee,
The
Ruthersburg.
reason I asked that, I'm probably not going to be an issue here, but if you happen to be sentenced to a prison sentence on another case before we get to sentencing here, I would have the ability at that time to run a prison term, in this case concurrent or consecutive to a prison sentence that you're already serving. Now you have to already be serving that or already been sentenced to that. I can't do that to some future possible unknown sentence. So if it hasn't been imposed yet, I don't have the authority to do that. But if by the time we come back for sentencing, if you've been sentenced to a prison sentence in another case, then I could do that. Do you understand that?
Yes.
Now, if you are sentenced to a prison term, in this case, upon your release from prison, you could be placed on what we call post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be for up to 2 years. You understand that?
Yes.
And if you are on post-release control at any point and you ever violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by this court. Do you understand that?
Yes.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. As I alluded to earlier, there's a mandatory fine that has to be imposed of up to $50,000. Now, it could be $1, it could be $50,000, but there has to be a mandatory fine in that range imposed. You understand that?
Yes.
In addition, I could impose another fine. It's not mandatory at all, but of up to $5,000. Do you understand that?
Yes.
So there's a maximum possible fine here of $55,000. Do you understand that?
Yes.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
You could also be ordered to pay, or you will be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison's not mandatory in this case. You are eligible for probation, or what's called formally community control sanctions. Do you understand that?
Yes.
You understand that just because you're eligible doesn't mean you'll automatically be put on probation. It means it would be considered by this court if that's what you're asking for. I'll look at all the information that gets presented, and I'll make the decision then that I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control sanctions, at any point it could be for up to 5 years of supervision. As the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in our Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes.
Further, if you are on probation at any point and you ever violate any of the conditions, we would have a hearing to see if you're what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions, including an order that you serve time in jail, or I could terminate your probation and send you to prison at that point. And at that point, it, again, could be 6 to 18 months, and that could be consecutive to any other sentence that you may be serving at that point, or that you're being sentenced to at that point. Do you understand that?
Yes.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to file that if I didn't think that was the right thing to do. You understand that?
Yes.
All right. Well, do you have any questions for me regarding the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
And again, do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have him review everything with you and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to?
No.
Do you need any more time to talk with your lawyer before we go forward with the actual plea of guilty?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we had a trial. I need you to listen to her and what she says because I'll have some follow-up questions for you. Ms. Gold for the state.
Thank you, Your Honor. The facts would show that on December 22nd, 2023, the defendant went to Dollar Bank in Painesville Township, Lake County, Ohio. The defendant went through the drive-through lane at the bank and withdrew $3,500 from Robin Spooner's account without the consent of Robin Spooner. At the time, Robin Spooner was 68 years of age and in a protected class.
Ms. Johnson, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes.
What, if anything, do you have to say about those facts as she presented them to the court? Are they true? Did you do what she said?
Yes.
Very well, then regarding count 1, charging with theft from a person in a protected class, a felony of the 4th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in open court. My understanding is before I came out here, you actually had a chance to go over that document with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with your client?
Yes, Your Honor. I reviewed the written plea of guilty form with my client. I read it. She read along with me. She indicated that she understood it. She signed it in my presence, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Ms. Johnson? You understand the document?
Yes.
Any questions for me about what it says?
No.
Did you sign it like your lawyer said?
I signed it.
Sorry?
Yes, I signed
Ms.
it.
Gold, you witnessed that too?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised about her constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, theft from a person in a protected class of felony of the 4th degree in violation of 2913.02A1. Counts 2 and 3 will get dismissed at sentencing, but I'm going to defer sentencing, order pre-sentence report and investigation. Issues with drugs or alcohol? Mr. Watson?
No, Your Honor. Actually, I don't believe that would be necessary in this case.
Order victim impact statement. Continued bond at $70,000, cash surety or 10% with an order that you have no contact with the victim. Ms. Gold, anything else for the record?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All rise.